Okay, well, this is part 5 of our discussion of libel, and you'll be pleased to know it's a fairly brief discussion, especially compared to the others. What we want to try to do is summarize uh, and reinforce a few things. First, the standard is that if a public figure, celebrity is suing, then they have to show actual malice. If a private plaintiff is suing, the private plaintiff has to show that the defendant was negligent. In the law, negligence is defined as failing to exercise reasonable care. Uh, None of those are very specific concepts. So let's look at something that tests that somebody might look at to determine whether a publication or an advertisement, news or information was negligent. First, was the source reliable? That if you can't show that you had a trustworthy source for the information, that it was overheard or in somebody else's conversation and you published it, then you were negligent because you didn't verify it. Was there an available explanation, or was a document misread or misinterpreted? Did it really say one thing when you thought it said something else? Did you make a big mistake in understanding in what the ACT people call reading comprehension? Um, the next one relates to something that's frequently depicted on movies and television shows about the media, where right before a story is published, a call is placed to the person who's going to be injured, most likely by the story, or most aggravated about the appearance of the story. It says, we're about to publish a story that says your company lost $500 million this week. What comment would you have about that? And they say, well, obviously you've got the wrong company because we made $500 last week. Let me look into it and correct whatever we put on our website. And sure enough, they had a mistake on their website, and they corrected it, and all of a sudden, whatever. But you never checked. You printed it without checking with an obvious source, including the subject of the story. And then was there sloppiness or carelessness in leaving out certain information, editing out certain information? Was it clear that an agenda was being pursued by the publisher, and that there was plenty of other additional information that was simply left out in order to make the story more salacious or more one-sided? These are the kinds of things that define negligence, which is the failure to exercise reasonable care, which is what a reasonably prudent person would do in the same or similar circumstances. The caveat that goes with this is that the people who compose juries in America are citizens like you and me, and citizens like you and me really expect people who provide us news and information to tell the truth and to be accurate. And when we're not, they're very unforgiving. Something that we might consider a mistake, an error, oops, something like that, a consumer is going to consider recklessness or stupidity or incompetence. If you ever publish anything, I guarantee you that one of the first comments you're going to get is, you should do more research before you do it. The public is very unforgiving of errors. And again, they're the people who serve on juries. We'll talk a lot more about this as time goes on, but basically there's a difference between truth and provably true. again, in our world, there are tons of truths in quotation marks that go around all the time. And sometimes when in conversation or otherwise, we use too much shorthand, and when that appears on a website, or it appears in an article, or it appears in an advertisement, then all of a sudden it becomes our burden to prove it, and that's not always an easy burden. If somebody says condensed soups are fattening, and it's just generally considered that condensed soups are fattening, and you print something that says Campbell's condensed soups are fattening, can you prove it? What does fattening mean? Does it mean they have a lot of calories? Well, are there not any slender people who eat soup? I mean, so you have to think about things in a lot of detail. We'll talk more about privilege as a defense when we get to privacy, but know that accurate reporting from an authoritative source is privileged reporting in the realm of privacy, and to some extent in the realm of libel. In other words, a report from an authoritative source that turns out to be wrong and injures somebody's reputation was said to be, use the word, privileged, and that the person who repeats it is not blameworthy. Again, go back to an example, say somebody's website said that they lost $500 million that week, and you do fail to check with them, and you report that they lost $500 million that week, and their stock tanks. Well, that hurts the company, and it's not true because it was an error on their website. But you also got it from a reliable source. You got it from the company's website itself, even if they later corrected it. So you're not as blameworthy for that as you might have been if you had not gotten it from such an authoritative source. This is called privilege, and it's used as a defense. Another defense that's accepted in some jurisdictions is called neutral reportage, which means that even if a story contained information that was false and defamatory about one thing, one person, one entity, as long as it was a balanced story and let people make up their own minds about what to believe, then the publisher is held harmless. An example of this would be, say, reporting that quoting one expert as saying somebody's product was defective, and then quoting another source talking about the same product, and that source said it was the best product ever. So you're not really taking a position one way or the other in the narrative. You're letting consumers decide for themselves. You're just telling them that they're conflicting opinions. One source says bad things about it, one source says good things about it. You report both sources. That's called neutral reportage, and it doesn't give rise to a cause of action by the party who objects to your use of the critical information. We mentioned briefly and just kind of passed over it, but we get into it in more detail sometime. Satire, parody, those things are out there. They're not actionable because people don't believe them. Remember, in order to injure somebody's reputation, and reputation is the interest you're trying to protect in a libel case, if nobody believes it, it can't be said to injure their reputation. You know, if I say Bob has leprosy and people don't believe me, then Bob's reputation isn't harmed. And in the same way, if there's a skit on Saturday Night Live or something like that mocks or something like or makes fun of or pokes fun of somebody, or uh, uh, if people don't believe it, then just kidding is a perfectly good defense. You can't injure somebody's reputation with information they don't believe. There's a special little rule for wire service or stories that come from networks. Local television sometimes will take a download of a package of a story that's done by a sister station or by the parent network or something like that, and they'll use it. Magazines and newspapers will pick up articles from wire services such as the Associated Press or Reuters, and they publish them. The special rule is that even though they had a choice in this area and chose to use the stories, the local people who air or print the story locally will be deemed to be a vendor and not responsible for the content. And if there is a cause of action, and there may well be, people will sue the parent, people will sue the network, people will sue the Associated Press, but they can't sue every newspaper that printed the same story from the Associated Press. Another factor here is the statute of limitations. Mississippi has a 1-year statute of limitations for libel actions. Other states have up to 3 years. The way a statute of limitations works is that if something's published that allegedly injures somebody's reputation, the injured party has 1 calendar year to initiate a legal action. And if a legal action is not initiated within a year, it cannot be initiated. It's barred by the expiration of time. Now, this is quite natural because obviously you're going to find out pretty quickly whether your reputation has been injured. But you have a 1-year statute of limitations. The statute does not restart when there's a republication or when something comes back up on the internet, as things tend to do, or there's a rerun of something on television. The statute generally starts at the moment of publication, and when it expires, it's over. The last thing we have to talk about in these 2 chapters is this matter of summary judgment. And this is kind of legalistic stuff rather than practice stuff. But a lot of times there are no issues of fact in a case, and a judge can dismiss it. The problem with being sued for libel is, there are all types of estimates, but generally in the range of $40,000 to $50,000 is what it costs to just defend a libel suit, whether you're perfectly right or you really messed up. But a lot of times you can, if there are no facts that constitute a libel case, you can ask for summary judgment, and the court will get rid of the case. But that, again, is a lawyer thing. We don't really need to worry about that. Something we do need to worry about is the notion of a retraction or a correction. The effect of a retraction or a correction in Mississippi is important, and this law here mirrors pretty much the rest of the United States. Number one thing is that when somebody says his or her reputation has been injured by a false statement of fact that you have published, that person is obligated, before commencing any legal action, before filing a lawsuit, to notify you and give you the opportunity to correct or retract the statement. You can't just ambush somebody after something's published 6 months later and file a lawsuit and say, oh, that's false and defamatory. There's a requirement in the law that a person who is alleged to have committed a libel be notified and given the opportunity to fix it. So anytime you're notified by somebody that something was wrong, you have to take that seriously, because especially if they say you need to correct that or you need to fix that, because they have met the first and only legal requirement as a precedent to filing suit is by asking for a correction. The effect of a correction in Mississippi is that punitive damages will not be assessed. There are two types of damages: actual damages that ostensibly put a person back where they were, the value of the reputation that has been harmed by this amount of money. And then there's punitive damages that can be added on, as the name indicates, as punishment for very bad conduct. There can be no punitive damages for if somebody prints a correction, a full and fair, as Mississippi law says, retraction or statement to try to correct the record. The world we live in has mostly digital publications, and the issue arises of, well, suppose something is posted that is false and defamatory, and it only stays up for a few minutes, a few hours, a few days, and then it's taken down and nobody can see it anymore. That does not remove the cause of action for libel by a plaintiff. If the plaintiff can show that the injury to reputation occurred as a result of something that was posted while it was there, even if it's later taken down, they can still file a lawsuit. So don't think that taking it, oh yeah, it's wrong, but we took it down, that does away with the legal consequences. You're still responsible for what was there. Okay? You can spend 6 or 7 years on libel. It's not nearly as big a deal in litigation today as it was in years past. There are a lot of reasons for that, and the pattern for you now is to get ready to know the rules and know the tests and know the elements, because test 2 will have a lot of hypothetical examples, and you tell me what elements are missing or whether the case is complete, things like that. And good luck to you, and I'll see you on the other side when we talk about privacy.